Well, I love romance. I'm a hopeless romantic. Romance is like everywhere in my life, but I had never read a romance novel.
Judge Lyman has declared Justin Baldon's case frivolous, and we've got Ron Zambrano here to break it down on Popcorn Planet. I'm Andy Sr., and it's great to have Ron back. How are you doing, sir? I'm great. Thanks for having me, Ron replied. We previously discussed some of Justin's wins, but now it's time to look at the other side. This case involves a motion for sanctions from Blake Lively's team, essentially arguing that Justin's claims were not only unfounded but frivolous, and that the court should award them fees. Judge Lyman ultimately agreed that the claims were legally frivolous and factually baseless, reprimanding the attorneys involved Liner Friedman and Mr. Seal League for violating Rule 11. However, he did not grant the monetary sanctions, making it a serious slap on the wrist rather than a financial penalty. Ron explained the significance. A formal reprimand from a federal judge is something no attorney wants. It signals that the judge believes the case should never have been brought and had no legal or factual merit. Rule 11 exists as a deterrent to prevent attorneys from filing frivolous lawsuits. While the court could have imposed financial penalties, it chose not to, but the record now carries an official reprimand. This is particularly notable because Friedman is a well-respected, seasoned attorney. Even for someone with his reputation, the judge found the claims, as pled, to lack merit. The motion for sanctions stemmed from Lively and Reynolds' prior successful motion to dismiss, and the judge's ruling clarifies that while the defamation claim against Reynolds wasn't deemed frivolous, much of the rest of the cross-complaint had no factual or legal basis. Such a reprimand can hurt an attorney's reputation and may discourage future clients from joining high-profile cases. Even without monetary penalties, it's a serious mark on the record. If you're in court and your firm, say, West Coast Trial Lawyers, is formally reprimanded for filing a claim, the judge finds sanctionable, that's a serious hit to your reputation. Even if it's not a scarlet letter, it comes very close. Part of the ruling also highlights that adding multiple parties, Steve Suitz, Melissa Nathan, Jennifer Abel, and others, was a key problem. Judge Lyman repeatedly notes that these individuals had no valid basis to sue Lively or Reynolds. It seems the plaintiffs combined everyone into one case, perhaps for convenience or publicity. But the judge makes it clear. These were separate lawsuits that should never have been merged. This raises questions about intent. Did the attorneys genuinely make an innocent mistake, or did they know combining parties was risky but went ahead anyway, perhaps for press attention? The reprimand is against the attorneys themselves, not just the clients. If formal sanctions had been issued, it could have triggered referrals to state bars, which would have serious professional consequences, given the high caliber of the firms involved. Friedman's and Massler's, it's reasonable to assume they advised their clients against these filings. But the clients may have insisted. These are experienced, sophisticated attorneys, not newcomers. They likely understood the risks under Rule 11, but may have thought it was a manageable gamble. Importantly, this reprimand affects the lawyer's credibility, not the core of Justin's case. The lawsuit itself still exists. Nothing in this ruling proves Justin's claims are invalid. Bringing in the Shapiro firm now provides buffer. Having another reputable name on the case helps mitigate the credibility damage Friedman's firm experienced. The judge has publicly noted that filings from Friedman and the other firm were legally frivolous and without merit, which does impact perception. But the underlying legal dispute continues. It seems Friedman's credibility with Judge Lyman has taken a hit, and that may explain why he brought in the Shapiro firm. Reading between the lines, Friedman, someone with a strong reputation in the field, likely saw this coming. Bringing Shapiro on board could have been a strategic move to protect Justin and the Wayfair parties, while also putting someone else forward as the primary face of the case. The Shapiro firm hasn't suffered any credibility damage, so they can handle proceedings in front of the judge without the uphill battle Friedman now faces. Credibility is huge in trial settings. Judges take note. Late discoveries or massive filings can become even more scrutinized. And once a lawyer's credibility is questioned, it can influence the way the court reacts to their arguments. By bringing in Shapiro, Friedman essentially creates a buffer, allowing the case to move forward more smoothly despite the sanctions and reprimands affecting him personally. Multiple legal experts have noted that Friedman isn't always a traditional trial attorney. His strength lies in settlement negotiations and pressuring opposing parties to give in before trial. From what we've seen, his strategy has often been about uncovering weak points and positioning them in ways that encourage the other side to cave. Given that, it makes sense that he would bring in someone else, like Shapiro, who can better manage the trial phase and present the case without the credibility issues Friedman now faces. Ultimately, this case has always been as much a PR battle as a legal one. Mudslinging, public filings, and media coverage have played a big role. Friedman's decisions may have been driven, at least in part, by ego, believing his usual strategies would succeed, but he's now facing an opponent who matches him in skill, which changes the dynamic entirely. Now, with Friedman facing a Rule 11 sanction, it's clear that strategies like adding multiple parties and filing broad cross-complaints may have worked in other cases. But this one clearly backfired. Every attorney has to read the room and ask, is this going to work here? Apparently, on this case, the answer was no. That said, it looks like Friedman and his team have adjusted their approach. Compared to last summer, they've clearly toned things down, likely after reviewing the court's feedback. But does this affect the judge's rulings against Justin? Personally, it doesn't seem likely. With the Shapiro firm now serving as the lead advocate in court, most filings and letters are coming from them, which preserves credibility in front of Judge Lyman. Rule 11 is very clear. The responsibility lies with the attorneys, not the clients. Lawyers are expected to advise their clients on what has legal merit and what does not. The reprimand is directed at the firms themselves, which means even attorneys who weren't directly involved are now associated with it. There was also a smaller point for Reynolds. His motion arguing that claims against him were sanctionable was mostly denied. He wasn't alleged to have personally made any defamatory statements to third parties, though under New York conspiracy law, a party can be held liable for defamation. The motion directed to the second cause of action was therefore denied, which could be seen as a subtle win for his side. Overall, this ruling doesn't provide clear insight into how Judge Lyman might decide on future motions. Like a summary judgment, what it does show is that he takes each claim seriously and evaluates them on their own merits. His review of the Rule 11 sanctions shows that he is willing to go line by line, claim by claim, to ensure the law is followed, regardless of broader narratives or media attention. Listen, Judge Lyman could have handed them all the wins here, but he really scrutinized the defamation claims. Reynolds didn't personally make any statements, but under New York law, he could be implicated through conspiracy. Lyman wasn't giving him a free pass, and it's clear he takes every claim seriously. This thoroughness likely foreshadows how he'll approach the upcoming summary judgment. Zooming out, the case is now snowballing toward an outcome. Settlement may have been possible earlier, but at this point, it seems unlikely. Lyman may trim Blake Lively's complaint, but unless she steps away entirely, the case is moving forward. For Lively, the stakes are high. Losing in front of a federal jury in New York could be damaging, especially with constant media attention. Think of what happened with Amber Heard. The consequences lingered long after the trial ended. From Justin's perspective, moving forward gives him leverage. Whoever is willing to see it through to trial generally holds more power in negotiations. If you were advising Blake, you'd likely suggest settling now, controlling the outcome, because even if she wins or loses at trial, appeals and ongoing litigation will continue to hang over her. Creative legal solutions, like a carefully worded resolution, could protect her while avoiding the worst-case scenario. But if clients are unwilling to listen, attorneys can only do so much. The case then careens forward toward trial. Justin, having already weathered much of the public exposure and expense, has reason to push forward. At this stage, he may be in the best position to convince a jury that nothing actionable occurred. Blake, on the other hand, will need to act decisively if she wants to exit. The clock is ticking, and outcomes could arrive any day. We'll be monitoring everything closely. When the next ruling or summary judgment from Lyman comes through, we'll break it down immediately. Make sure to subscribe, hit the bell, and stay tuned. You don't want to miss it. Thanks so much for watching. And thank you, Ron, for your insights today. Thank you, Ron replied. Likewise, I said.